Concerns about data security and protection of vulnerable groups were raised in Parliament. This as the Registration of Criminals Act was amended to allow, among other things, police to enhance the collection of DNA and other information from more suspects or offenders. This applies not just to serious offences that result in a criminal record, but also other less serious crimes which carry a prison sentence. Geraldine Yap tells us more.
How wide is the access?
A total of 12 MPs spoke during the debate on the bill. While they expressed support for expanding the police's DNA database, they also raised several concerns. These include how the data collected will be protected from misuse and cyber attacks.
Can the minister confirm if the DNA database would be stored in a standalone computer or in systems that are linked to the internet and therefore susceptible to cyber attack? How wide is the access to the DNA database?
Under what context would it be necessary for a police force to share DNA information with foreign agencies? And how safe would the data be once it has been ported over?
Minister of State for Home Affairs Sun Xueling says the DNA database is managed by the Health Sciences Authority and hosted on a secure standalone network. She adds that only authorized individuals can access the database, and all access can be traced using an audit trail to detect any data modification.
As for sharing with foreign law enforcement agencies, we will share particulars of DNA information of persons who have been convicted of a registrable crime for the purposes of foreign investigations or proceedings. Further, the foreign law enforcement agency must comply with the conditions prescribed for the transmission of such information and any other conditions that the Singapore authority may impose.
Another concern raised was that of protection for vulnerable groups in the process of collecting DNA samples. MPs wanted to know how the new law would ensure that appropriate consent is given when invasive blood samples are taken from those below 16, as well as those with special needs or disabilities.
If the individual is below 16 years old, the written consent of his parent or guardian has to be obtained. With regards to individuals who are above 16 years old, where the police assess that the individual may not have the mental capacity to give consent, the police will err on the side of caution and not take an invasive blood sample.
She adds that it will be an offence for a parent or guardian of an individual below 16 not to give consent for an invasive body sample to be taken without reasonable excuse.